You give us an overview of the bill as well as introduce your guest.
Thank you, Mr. Chairman, members of the committee. This is unauthorized access to a computer, and basically what this does is we had a situation in Kennesaw. As you know, there was a breach, and with the current statute the way it is right now, in our state there are two other states just like us, which is Alaska and Virginia, that it is not illegal for someone to have access into your computer without permission. If they move something or remove it or move things around, manipulate it, then it does fall under that statute. But currently it does not. And so working with the AG's office over the summer, this is a fundamental basis that needed to be changed, a fairly simple change to be able to provide that the tools they needed to be able to prosecute in a situation like that in the future. Next to me, we have David, who represents the AG's office. So, David.
Thank you. David McLaughlin. I'm involved with the prosecution unit. One of the things that came to light when the KSU story broke was sort of this, everybody shrugging their shoulders like, why isn't this guy being arrested? Why isn't this guy being prosecuted? And we have a computer crime statute that involves computer theft. Computer trespass would be the closest fit. Unfortunately, in the realm of computer trespass, if I go into your computer system, network, home computer, laptop, business, personal, it doesn't matter, and all I do is I get access and I'm in there, absent anything else, that's not a crime. And it should be a crime. And that's exactly what this bill is designed to do. We canvassed all the other states, taking a look at how they approach the situation. Some do it more complicated, some do it less complicated. What we did is we synthesized all those statutes and we looked at a good, solid, straightforward approach to dealing with this situation. And I think this bill does just that. These intrusions are often a precursor to other forms of malicious conduct, malicious activity. And frankly, if we can do something about it on the front end instead of waiting until something happens later, then we'll be all the better for it. Thank you.
Thank you. Senator, if you or David wouldn't mind, just because this is a new version, can we just go through the underlying sections of the bill briefly?
Sure. And Mr. Chairman, one of the things I would say is obviously we worked with the AG's office. We've worked with a coalition that includes Comcast, Google, and others on this bill. So.
Yeah, sure. So what this bill does in Section 1 is it modifies the current language that we would find in the computer trespass section. And it defines unauthorized computer access as being any person who accesses a computer or computer network with knowledge that such access is without authority shall be guilty of the crime of unauthorized computer access. So it's creating a new crime. And that crime would be unauthorized computer access. There are a couple of exceptions that are built into this. One involving parents or guardians and trying to preserve their autonomy to be able to decide what happens or doesn't happen with their minors' computers, and also carving out any computer network for legitimate business activity. And this is the language that we worked with the industry on. And that was sort of a collaboration of efforts between my office and the industry. Some of the representatives which are here and could probably speak to that much more so than I could. Section 2 is the venue provision, and it sets out a variety of different places that the crime could be prosecuted. One of the concerns in this realm of technology, and it's not just in unauthorized computer intrusion, but we're talking theft, forgery, you name it. Because of this digital world we live in, trying to determine where a crime takes place as a prosecutor is becoming more and more difficult with every passing day. There's not a case that comes into my office where one of the first things we say is, okay, well, where did this crime take place? And one of the things that we tried to do with this bill, and we try to do when we are modifying existing legislation in other areas, is be a little bit more broad-minded with venue. For example, in the identity fraud statute, it used to be that you could only bring a case wherever an act of the fraud took place. Well, so much of the fraud takes place either in other states or other countries, and we're disenfranchising our Georgia identity fraud victims. So we redefined the venue to include where that victim resides. And now we're able to prosecute people we were never able to prosecute before. Similarly, this bill very broadly defines some areas of venue that will let us go after these criminals wherever they may be here in Georgia. And we have criminals all over the world, let alone all over the country.
Thank you. Appreciate your updates. Are there questions from the committee members? Senator Dugan?
Just to follow back up with that, the offender lives in Minneapolis. How do you go get them?
Same way we got somebody, I don't want to commit to Minnesota, maybe in Wisconsin, but we had a case involving Kennesaw State University where one of our offenders is in Minnesota. And we take a warrant, we get it executed up there. If they don't waive extradition, we go to the governor, we get an order, we go and get them. And we have extradited many people in many cases over the years. I've got a guy who is in, I won't tell you what country he's in because it's a very fluid situation, who has escaped, and we are working internationally to bring him back. So someone being in the United States is easy pickings.
So just to follow up, if I may.
Please.
So they don't have to have the same type law in the state in which you go get them because solely they violated Georgia law.
That is absolutely correct. And again, the best parallel I can give you is that identity fraud statute, because so much identity fraud takes place where somebody may get my name or social security number, and the fraud may be taking place in California and in Boston, Massachusetts. Well, by golly, my identity is my identity, and my identity is where I am. And we've said as a state, that crime takes place where you are, namely your residence. And so this is common for elements of crimes to really happen outside of Georgia. But Georgia, specifically the General Assembly, has the right to decide where those crimes take place. And interestingly, our Supreme Court, years ago, comprised mostly of different people than are there now, initially found the identity fraud venue provision to be unconstitutional, saying, well, the crime takes place where the acts take place. And we moved for reconsideration, and we said, no, the General Assembly decides where a crime takes place. And they said, you know what, you're right. And so they reinstated that law. So as long as you all decide something's a crime, then it's a crime, and we'll go get them.
Okay, thank you.
Thank you. Next, I've got Senator Williams.
Thank you. I've got just a couple of quick questions. I have a 20-year-old son who I gave a phone to for Christmas. I am paying the bill. Who owns that phone?
If you make him 17, it's a lot easier for me to
I wish I could sometimes.
that is going to be pardon?
Whoever the accounts and everything.
Well, it could be either whoever is count, but it's basically what did you do with the phone? If you gifted him the phone, then it's his phone. You know, if you have a contract with your son regarding you're 20, this is your phone, but by golly, I can access it whenever I want because I'm still your dad and I've bought you your phone. Then that's a different issue. But ownership depends on your intent when you gave it to him. If it's just a phone that you bought, it's in your name, the account's in your name, you pay the bill, and you say, son, here's this phone and you can use it, then it's probably still your phone. Now, getting away from the father and son relationship, we get into all kinds of issues regarding expectation of privacy, guarding against warrantless search and seizure and that sort of thing. Which
The next question, a employee phone.
Employee phone is
That's employer?
That's
The employer's phone. So the employer has access.
I have my state phone and I have my phone.
Okay.
And this is my phone and that ain't my phone. And so I cannot and should not, and whoever's listening, I do not use it for I fully understand and expect that my office could review it at any point in time they want.
Okay.
They may well have software that they can review my texts at any point in time. I don't know that they do, but I shouldn't be surprised if they did.
Okay. And then also, current statute is if I gain access to a computer system or a computer, just the access is not a crime, but if I copy something, delete something, move something, if I do anything to alter it in any shape, form, or fashion, that then is the crime.
That is correct. And that falls into, and we're talking about Code Section 16993. Computer trespass section is B. And it talks about deleting or in any way removing temporary or otherwise, computer program or data. That's one.
That includes copying as well.
Removing, I would say, is copying.
Okay.
Because that's how you extract it. That would in effect be copying. That would be removing. Number two would be obstructing, interfering, or in any way interfering with the use of a computer program or data. That's the vernacular is the denial of service attacks that we would see.
Yeah.
When people are getting locked out. Number three is altering, damaging, or in any way causing the malfunction of a computer network. So there is a pending case that we have, for instance, involving a state agency where a former employee went in, changed passwords, and deleted a bunch of data. That clearly falls within the parameters of computer trespass. But an outsider that comes in, probes, looks around, looks to see what files are there, looks to see what your structure is. They're in your network, but they are not doing anything that's prohibited by our current statutory framework. That's what we should be most afraid of, is a notion that I could be sitting at my home on my PC and that someone may be in the background just poking around. And that's what we want to say you just can't do.
All right. Thank you.
Thank you. I will need some attorney's assistance. My 22-year-old son's behind me. We'll be working on a contract on his cell phone after this meeting's over. So. Okay, next, Senator Watson.
Just, at the appropriate time, make a motion to do pass.
All right, we got a few more questions, but I'm gonna come back to you.
There's a reason we kept it simple. It's
Senator C, I've got you next.
Thank you, Mr. Chairman. I just want you to complete. You said if that child that he referenced was 17, it would be a different answer. Would you answer that now if it's under the 17-year-old, if you want to use that one?
lawyers in this world will tell you prosecutors really don't know law. So let me start off with that caveat that I'm not, I don't know about family law, I don't know about guardian, but if you've got a minor, then I do think ownership issues become a little bit more complicated. Certainly privacy issues are a lot more complicated when we're talking about a parent and whether or not they can look at their child's stuff, whether or not they own their child's stuff. And so I think, while I can't give you the definitive legal family law answer, I can tell you it's different.
Thank you. I've got Senator Lee Anderson next.
How would you treat if the hacker was a juvenile?
Laws apply to juveniles. The juveniles are dealt with in the juvenile system. All of our existing code sections, of course, are applicable to juveniles. It's how they are handled that is fundamentally different, and they would be handled in the juvenile court system. It would be adjudicated under the juvenile court rules and procedures. Again, that's not an area that I'm that well versed on, but in our state, if you're a juvenile doing certain kinds of things, those generally don't follow you the rest of your life. If you murder someone as a juvenile, that's different. And there are situations where certain ages of juveniles can be prosecuted in superior court as an adult. This isn't going to be one of those crimes.
Thank you. And Senator Jones.
Thank you, Mr. Chair. On line number 19, is there any concern that from a prosecution standpoint that you're actually almost providing a defense? Because it seems like you're almost setting up a strict liability statute on some level, because you're saying you don't want people in there poking around. They don't have to do anything with the material. You don't want them in. And so we say legitimate business activity. It seems clear on its face, but also at the same time, person who has some type of business connection with somebody can go in and poke around, and then you're almost providing a defense to where they can say, "Oh, it was originally for business."
Yeah, and this is the language that we were working with the industry, and one of the things that we wanted to do was to make it as clear as possible, but not complicated. That when we're talking about legitimate business activity, when you look at how that is addressed in common law, how that's addressed by the courts, how that's addressed in contract, you're almost always looking at some pre-existing relationship that has created a something that you would be able to define as a legitimate business activity, as opposed to I may have a legitimate business. Okay, I may have a business, And what I like to do is I like to go around and poke around people's computers looking for potential clients or looking for interest or whatever the case may be. That's not going to be a legitimate business activity insofar as the statute is concerned, because there's no pre-existing relationship there. There's nobody that could assert with a straight face that I've got a legitimate business activity to go into Senator Jones's computers because I'm a legitimate business. Now, again, this is the language that the industry has worked on with us on, and I think they're present. I think they can speak to it better. As a prosecutor, there's a lot of places in the code where you can say, well, that's a built-in defense. And we're not really daunted by those. There's a lot of times that there are defenses that are seemingly implicit, and then there's other times there's actual affirmative defenses, and we deal with those all the time throughout the code.
Because you're the author of the bill, maybe that would be something still to look at. Because I wasn't really talking about somebody just poking around because they have a business. What I'm really thinking about is an employer, not on a business phone, who is maybe stalking his employee and is on him or her phone, their personal phone, and they're just in there. But that person could hide behind and say, oh, it was a legitimate business activity. I thought they were stealing something or something. Had nothing to do with that.
Yeah, absolutely. Yeah. I wouldn't be concerned at all about what you just described. And actually, in that phone world, what you're just describing, that gets into both federal and state wiretap violations that I would look at.
Thank you. Any other questions from the committee?
Yeah.
Senator Williams.
Apologize for dragging this out, but that question brought up a question in my mind as far as the Verizons, the AT&Ts. I might have internet access through one of these, and this would give them the ability to access my computer, whether it might be my Wi-Fi or whatnot, so they could legitimately have a business reason to access my computer.
Yeah, I think if you have a contract and agreement with Verizon, AT&T, where they are service providers for you, and you've agreed they're your service provider, and there are things like patches and things like that that are necessary. I think this is what this is designed to address. Again, the industry folk are here. I don't speak that technical jargon, and they would be the ones to ask.
Okay, but it does give them access to my computer legally.
Yes.
Okay.
Just to clarify that, Senator Williams, I believe you give them consent to do that when you sign up, right? So you, I'm not sure everybody reads that disclaimer, right, but they probably should. So.
And to the chairman's point, and again, I'm a child of no computers, so the best equation that I can make is the landlord-tenant, and we all probably rented apartments in our youth. Maybe some of us are now, and even as a lawyer, I've never read a darn one of those leases. I'm just going to be honest. And I bet you every last one of them says, landlord can come in anytime they want and do anything they want in my apartment, whether I'm there or not, whether they announce it or not. I mean, we just don't read that.
Well, I appreciate it very much. And first, I want to thank you, Attorney General Carr, and all of the folks on the team for doing all the great work to put away the bad actors and help keep us safe. So, do you have any follow-up comments? I want to give somebody a chance to speak if they'd like to. If not, we'll let you wrap it up.
No, again, Mr. Chairman, I'm sorry, but it was LC 297797S because I know we've had various
Correct.
versions, so just make sure of that. And I appreciate the committee hearing this.
Thank you. I do not have anybody signed up to speak for or against these bills. Unless somebody would like to, I'm going to recognize Senator Watson.
Thank you, Mr. Chairman. So I'm making a motion for Senate Bill 315, and Senator Thompson did the LC number 297797S.
Correct. I've got a motion on the floor. Do I have a second? Yes, that was a motion to pass. Okay. All right. Thank you. Thank you. And we have a second from Senator C. Appreciate that. Is there any further discussion? Hearing none, we'll call a vote. All those in favor will please say aye. Aye. All opposed, please say no. Motion passed unanimously. Congratulations.
Thank you, Mr. Chairman, members of the committee.
Thank you.